Hello everyone, welcome to Learn Law with AKP. In today's class, we are going to discuss the definition of guarantee under section 126 of the Indian Contract Act 1872. This is a foundational topic because without understanding the definition properly, you cannot understand the rest of the guarantee concepts. So, I request you to listen carefully and understand each word of the definition. Let's begin. Now, let's look at the legal definition given under section 126. It says that a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. Now, don't get confused by the legal language. Let's break it step by step. First part, perform the promise or discharge the liability. This means taking responsibility to complete someone else's obligation. Second part, of a third person. This is very important. It means the guarantee is always about another person, not yourself. Third part, in case of his default. Default means failure. So, the responsibility comes only when that person fails. Now, let's combine everything. A contract of guarantee means one person promises that if another person fails, he will perform the obligation. Let's take a simple example. A takes a loan from bank. B tells the bank, if A does not pay, I will pay. Here, B is giving a guarantee. So, this is the meaning of guarantee. Now, section 126 also defines three important terms. First is surety. Surety is the person who gives the guarantee. Second is the principal debtor. He is the person whose default is guaranteed. Third is the creditor. Creditor is the person who to whom the guarantee is given. Creditor is the person to whom the guarantee is given. Let's understand this with a real life example. In a bank loan, the borrower is the principal debtor, the bank is the creditor, and the guarantor is the surety. So, always remember, guarantee always involves three parts. Three parties. This is a very important exam point. Now, let's understand the concept more clearly. Guarantee always involves a third person. That is why we say it is a three-party contract. Another important point is that the liability is conditional. What does conditional mean? It means it depends on something. Here, it depends on default. So, the surety is not immediately responsible. He becomes responsible only when the principal debtor fails. So, guarantee is not directly liability. It is conditional liability. Now, let's take example to understand clearly. A borrows money from a bank. B gives guarantee. Now, as long as A pays properly, B has no responsibility. But if A fails to pay, then B must pay. So, B is acting as a backup. This example is very important. If you understand this example, you will understand the entire concept of guarantee. Now, let's understand an important case law which explains this concept. This is the case of Birkmyr versus Darnell. This is a classic case which clearly explains what guarantee means. Let's understand what actually happened in this case. One person promised that he would pay the debt of another person if that person failed to pay. Now, the question before the court was, is this contract of guarantee or not? The court carefully examined the situation. It observed that there are three parties involved: one person who is giving the promise, one person who has the actual liability, and another person who will receive the payment. So, the court held that this is a contract of guarantee. The principle established is very important. If a person promises to pay the debt of another person in case of default, it is a contract of guarantee. So, remember this simple line: pay for another person is guarantee. This case is very useful for exams. Now, let's summarize the key features of guarantee. First, it involves three parties. Second, the liability of the surety is secondary. Third, the liability arises only on default. These 3 points are very important. If you remember these, you can easily write answers in exams. Now let's conclude this topic. The definition of guarantee under section 126 explains that one person promises to perform the obligation of another person in case of default. It involves three parties: surety, principal debtor, and creditor. The liability of the surety is not immediate. It arises only when the debtor fails. We also understood this clearly through the case of Birkmyr versus Darnell. So, this definition is the foundation of all guarantee concepts. For example, in your exams, always remember definition, explanation, example, and case law. Thank you. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. Stay tuned for the next topic.